In the previous lesson, what we did was spend a little bit of time talking about conditions as a type of term within a contractual arrangement. We talked about what a condition is, and we talked about how conditions really strike to the root of a contract. They really strike at the heart of a contractual agreement. And we noted that this is reflective in the ways in which this would then relate to the breach of a condition and how this would change the scope of remedies that may be available in those circumstances. This lesson is going to talk about warranties. Warranties being a different type of term that exists in a contract and what they mean, how they operate, and how we can determine what a warranty may be. So we noted in the previous lesson that conditions are fundamentally the main and most fundamental contractual terms available to the parties. The next type of terms that are express terms, at least within a contract, are warranties. Of course, there is this existence of what are known as implied terms, which we will get to in future lessons. So the key element of the condition within the contract is that a condition speaks to the heart of the contract itself. It is the main thing that the contract is established for, and it is the main thing that the contract exists to achieve. If we remember back to the previous lesson, the Poussard and Spires case, the key element, which was identified to be a condition within the contract, was that the singer in question is able to perform at the operetta. This was a contract between the operetta and the singer for the singer to perform. So the purpose of the contract is for the singer to perform for some payment. And so the heart of the contract, the fundamental part of the contract, is actually the idea of them singing, the contractual obligation for them to be singing. This is because without this action on the part of the claimant, i.e. the contract itself, the singing itself, then the contract would be rendered effectively useless. So we can essentially make a distinction, therefore, between a condition on the one hand and a warranty on the other, given that a condition pertains to the ability for a contract to continue. And so, as a result of this, you might have lots of different terms in a contract. Okay, all of these different terms and conditions do all different kinds of things. Okay, conditions are required to allow for the contract to continue, and then warranties may or may not be breached, and there may or may not be any kind of remedy in place, but that there could still be the continuation of the contract if this was to happen. And so this gives us a very interesting illustration of what a warranty is. In some cases, contracts will have terms which are somewhat subordinate to that of the key conditions, to that of the main element of the contract itself. These are terms which will still require performance, and if they are not performed, for example, there could still be the attachment of a remedy, but they are not terms which necessarily destroy the whole purpose of the contract. Let's remember then back to the case of Poussard and Spires, and let's say we have a contract, therefore, between the singer and the operetta for the singer to sing at the operetta. Let's assume that within this contract there is also a term that says that the singer has to sing wearing a purple hat. They should sing wearing a purple hat. The contract itself is a contract for them to perform at the operetta, and there is another condition here that says that the singer has to really perform we want the singer to perform in a purple hat. If the singer was not ill, as is the case in this particular illustration, but in fact was able to sing, but didn't sing in a purple hat, this is still a breach, technically, of the contract. There was still an obligation to perform that part of the contract, but it doesn't render the contract meaningless. The contract can still continue because they can still go and perform and do the singing. So whereas the condition is the part of the contract that says that the singer has to sing at the operetta. The warranties might be the condition, or the term, should I say, that they do it in a purple hat. Because if they did not, if they fail to do this, there could still be a remedy. Maybe there might be a financial penalty for not performing in a purple hat. But the terms themselves do not destroy the whole purpose of the contract. So if a warranty is breached, it is likely that this would not break the contract itself. It is for this reason that the remedy available to the injured party will be lesser than if it was with a breach, compared to lesser with the breach of a warranty, compared to that of a breach of a condition. If a breach of a condition takes place, then this strikes to the heart of the contract. Likely the contract cannot be performed, it cannot continue, and likely therefore there will be quite a significant remedy. With a breach of warranty, there may only be damages available, rather than a discharge of one's obligations. Remember, owing to the principle of consideration, when a contract exists, there is obviously requirements for both parties to actually do something in order for that contract to actually be valid. So, if a condition is breached by one party, then you might be discharged of your obligations as the other party to actually perform or do whatever it is that you were required to do as part of your consideration. But if it is a warranty, then there may only be damages available, and you might still have to continue with your obligations. So the case of Bettini and Guy from 1876 gives us a very strikingly similar set of circumstances of Poussard and Spires. In fact, in both of these cases, we can compare to show the different distinction between a condition and a warranty. It involved a singer who was under contract to perform in a number of different theatres. Just like with the previous case, he was in fact replaced and sued for breach of contract. But this wasn't because she failed to turn up to the performance because she was ill, like in the case of Poussard and Spires, but rather she failed to turn up to the rehearsals, something that was also stipulated in the contract. So the contract was for you to perform at an opera, or perform in a theatre, to do some kind of theatre performance, okay? And there was also another term in the contract that says you also have to turn up for rehearsals. They failed to turn up for rehearsals, and so they were replaced, and there was a suing for breach of contract, similar to that of Poussard and Spires. Unlike the previous case, however, the claimant here was successful. This was because the term which stipulated that they go to rehearsals was not considered to be a condition, but instead it was considered a warranty. Okay, so therefore, if it was a condition, it would have meant that there was a breach of contract and there would have been a breaking of the contractual arrangement. Instead, it was a warranty. The defendants would have been able to sue for damages for the breach of warranty. They may have been able to sue for some kind of compensation for failing to turn up to rehearsals. But because it was a warranty and it wasn't a condition, it wasn't something that struck at the heart of the contract, they were not entitled to repudiate and terminate the contract in its entirety.